that we had to add to the contract to provide validity to the contract. The notices that were required by law were as of January 1, 2012. We got these inserted in the contract, but if you don't use the contract, those notices aren't given. Let me explain. If your property on a 1 to 4 family residential property or an unimproved contract or a new home incomplete construction or new home complete construction is subject to a mandatory property owners association, there is a new notice that is required by law that states that this notice must be given by a seller to a purchaser on or before execution of the contract, and if not given on or before the execution of the contract, then the buyer has the right to terminate for any reason. If your property that you're dealing with is not subject to a mandatory property owners association, then this notice isn't required, so it doesn't matter if you use the new form or the current form that you're using. But many of you deal with properties that are subject to property owners association. The next notice that is required by law, and it was effective as of January 1, 2012, was the notice with regard to private transfer fees. Not sure you understand what a private transfer fee is, but basically it is a fee that someone can put in a deed restriction that will continue to run with the land, and every time the property is transferred, a fee is due, however that fee is required. And the legislature was trying to do away with private transfer fees, basically the ones that sometimes the developers were putting on the property and basically creating a retirement fund, such that every time a property sold, 0.5% of the sales price would be due to a retirement fund. I'm being facetious, but some kind of fund. And the legislature thought that for public policy reasons, those should be disallowed. And in the last legislative session, they did disallow them on a go-forward basis, could not retroactively disallow those that were already in place legally. So they said, okay, if a piece of property is subject to a private transfer fee that is no longer allowed to be to encumber a piece of property, then the notice has to be given. So there is that notice as well. That notice must be in the contract per the statute. So again, if your property is subject to a private transfer fee, that notice must be in the statute. And again, failure to give any one of these notices on or before execution of the contract allows the buyer to terminate the contract. If you will get, it's my understanding that MetroTex emailed out to you yesterday a copy of the presentation and a copy of the forms. And if you would pull the forms and get them in front of you, you'll be able to see the notices that I am talking about. If you will look at your 1 to 4 family residential contract form 20-11, and if you will look on page 3 under the notice provision, paragraph 6E, which is title notices, you'll notice under 6E2 a whole new paragraph under there, and it is the bolded and underlined paragraph that begins section 207.003 property code. It simply is a disclosure that the owner has the right to get all the information due from the homeowners association or the property owners association. And this notice must be given on or before the execution of the contract, or the buyer has the right to terminate the contract. So you just see it's just an additional notice that has to be given to the buyer on or before execution of the contract. Unfortunately, if you have a copy of the presentation that was emailed out to you yesterday, there was a typo in it that this slide that you see on your computer has fixed. We just left out one line. The homeowners association must now provide to the owner and or buyer the style and cause number of lawsuits to which the property owners association is a party, other than lawsuits relating to unpaid ad valorem taxes. We left out a line in the presentation that was sent to you. Now, you also need to note that as of January 12, 2012, it was presented to TREC that they actually underlined and bolded the wrong provision on that notice. If you'll look at your form, you see that says underlined and bolded the paragraph that says Section 207.003 Property Code. In reality, it was the 3 lines above that notice, and these lines were already in the contract, but the new statute requires those 3 lines to be bolded and underlined. Those are the sentences that start saying, you are obligated to pay assessments to the Property Owners Association. The amount of the assessments is subject to change. Your failure to pay the assessments could result in enforcement of the association's lien on and the foreclosure of the property. Just note that that's basically a typo. The same notices are in your contract, but when the contracts are put up on zip forms, which they are not there yet, but when they are put up on zip forms, this typo will be corrected, and the date on the forms that contain this notice will be changed to 1/12/2012 as opposed to 12/5/2011. The other notice that is required is the private transfer fee notice, and that was inserted in new paragraph 6E8 of your 1 to 4 family residential contract. And all the notice says is, if the property is subject to a private transfer fee obligation, Section 5.205 of the Property Code requires seller to notify buyer as follows. The private transfer fee obligation may be governed by Chapter 5, Subchapter G of the Texas Property Code. That's all the notice is. It doesn't say that this property is subject to a private transfer fee. It just says if it is. You won't know if your property is subject to a private transfer fee oftentimes until the title commitment is issued to you. So this notice is something that you need to go ahead and be sure you have in your contract just in case. Okay, I wanted to give you some information as to what contracts were affected by these notices. It is the 1 to 4 family residential contract, we just went over that. The new home contract, both the completed construction, which is Form 2412, and the new home contract, which is the incomplete construction, Form 2312, and the unimproved property contract, Form 9-10. But please note, in the unimproved property contract, the private transfer fee notice is in paragraph 6E9 rather than 6E8. And because these contracts also contain the Property Owners Association new notice, these contracts needed to have the typo fixed, changing the bolded underline provision, and all of these contracts will eventually reflect a revised date of 1/12/2012. For those of you who may have questions, what I'm talking about, if you look in the top right-hand corner of your contract, you'll see a date. That is usually the date which those contracts are accepted by and approved by the Texas Real Estate Commission. And when they are approved by the Texas Real Estate Commission for use, that means you can use them as of that date, but then they will always set a mandatory date a few months out to get the word out to their members. So what you see now in the forms, if you're looking at the form, you'll see in the top right-hand corner a 12/5/11 date. That's when these contracts were accepted by and approved by the Texas Real Estate Commission, and it wasn't until January 12th that we caught the typo. So when the contracts get posted, they will be January 12th, 2012 for these forms that contain this notice. For right now, also, I want to point out, we did check zip forms. Zip forms, unfortunately, does not have these contracts up yet, but we're recommending you start using them as soon as possible. TAR does have these forms up on their website, and these forms are also on the TREC website. Now, certain of your contracts are only affected by one of the notices. We've been talking about the Property Owners Association notice, and some people have asked me when I've been speaking about this, what's the difference between a Property Owners Association and a Homeowners Association? Are they the same thing? Well, they technically are the same things. However, when I refer to the Property Owners Association and I refer to the law requiring the notice, I'm referring to a law that only affects property owners associations governing single-family detached homes, one unit, not condominiums. The Condominium Owners Association Act does not have this new notice requirement. So, back to the contracts that are only affected by one notice. The residential condominium contract, it is only affected by the private transfer fee provision. That private transfer fee provision must be a notice given to a buyer by a seller, and that notice must be in the contract. That's on the condominium contract. It does not have any new notice with regard to the declaration and the assessments imposed by the Property Owners Association. Farm and ranch contract also only contains the private transfer fee notice because the farm and ranch are not affected by the Property Owners Association. We will answer questions with regard to your Property Owners Associations at the end of this presentation. Wanted to bring up the other contract changes. While we had to make these notice provisions available in the contract, we had some other changes that we wanted to fix. They were on our wish list for a while, and we saw that there were some issues. First off, under paragraph 6B, and if you'll look at the 1 to 4 family contract, forms 20-11, generally we use the 1 to 4 family contract as the template, and if the changes that we make to this form then relate to the other contracts, we just carry them forward. So let's use the template, the 20-11 form. And if you'll look at paragraph 6B of the contract, there was a blank or a problem, the Broker Lawyer Committee felt, under that provision 6B on delivery of commitment and exception documents. Under that provision, under the current form, before this new form, we just said that the seller is obligated to deliver the commitment to the buyer within 20 days after delivery to the title company, after the contract's delivered to the title company. But if the commitment and exception documents aren't delivered to the buyer within those 20 days, then there's a right to extend it. And then it just said that it just left it blank. Our problem is what if the commitment was never delivered to the buyer? Yes, the seller was in default, but is that the remedy the buyer wanted to pursue, the default remedy? We felt that if the buyer doesn't get the commitment within the time specified, they shouldn't be required to enforce default remedies or hang on to the contract until they can't close. We added a sentence, the last sentence under paragraph 6B. It says, if due to factors beyond seller's control, the commitment and exception documents are not delivered within the time required, buyer may terminate the contract and the earnest money refunded to buyer. So the buyer isn't just left in limbo. We added that provision. We also changed back to the Property Owners Association under paragraph 6E2. Under the current contract, we had discovered, last version of the contract, that some properties are subject to multiple associations. Some people call them overlay associations. And the notice by the law was required for each association, and the notice was already in 6E2. So in the last version of the contract, we actually made the notice effective for plural associations. And if you look at it, we just added an S in parentheses after associations so that if the property was subject to multiple associations, the notice would kick in. But also last version, however, we felt that if a buyer wanted information separate and apart on each association, basically the subdivision information that is covered by the addendum, that a separate addendum should be used for each association. That became problematic because oftentimes you didn't even know the names of the associations. So we took out that requirement that you need to use a separate addendum for the addendum subject to the Property Owners Association. We took out the language that you had to use a separate addendum for each association if the buyer is concerned about the information. If you will look on paragraph 6E2, the last sentence of 6E2, it says, if buyer is concerned about these matters, the TREC promulgated addendum for property subject to mandatory membership in a property owners association should be used. We used to have language saying for each association. Now we are saying you can use one addendum covering multiple associations. The next change we made was a result of some issues that we found the inspectors were coming up against on your inspections. Under paragraph 7A of the contract, that is the paragraph that deals with inspections. It allows a buyer to make inspections of the property. That's the provision for inspections. It's not the option period. It's the inspection right is under paragraph 7A. Under 7A, we had a requirement that the seller had to turn on utilities for inspection. Unfortunately, the inspectors were claiming that the sellers oftentimes didn't turn on the utilities timely. The buyers would request an inspection, the inspector would go out to the property, and the utilities wouldn't be on the property, and so they'd have to make another trip to the property. And this was costing inspectors and consumers that. So what we did is we added in paragraph 7A a requirement that the seller not just turn on the utilities for inspections, but rather under 7A, we now say seller at seller's expense shall immediately cause existing utilities to be turned on and shall keep the utilities on during the time this contract is in effect. So it requires the seller to immediately turn on the utilities and keep them on. Now I know for many of you who represent REO lenders and sell REO properties, the lenders do not want to turn on the utilities. If they use this form and don't otherwise change it by their addendum that they add, they will be legally obligated to turn on the utilities. Also, you do have some sellers. We have run into where some sellers don't want to turn on utilities because they have to pay penalties or connect charges or whatever. Well, if the sellers are refusing to turn on the utilities, they're going to have to change this provision in the contract, but a buyer may not accept it because I would argue they can't make valid inspections of the property. So this requires the seller to immediately turn them on. The next question is, what's immediately? Well, within a reasonable time, once they get the contract executed, they need to make effort to turn on the utilities and then leave them on for inspection. Another change that we made under the contract is under paragraph 7F that has to do with repairs. What we did here was simply eliminate a provision that was never used and would never have been recommended to be used. Under paragraph 7F, the seller has always been required to complete repairs on or before closing. However, we did have a provision in there that said if the seller didn't complete them on or before closing, then the buyer had the right to extend the contract 15 days, go in and make the repairs, and require reimbursement from the seller. I will submit to you, if I could see your face and ask you to raise your hand, how many of you let a buyer go do that? None of you would raise your hand. I would not recommend a buyer go in and make repairs to a seller's home before they buy it. So nobody used this provision as it was written. We changed this provision now, saying, okay, seller, if you don't perform like you're supposed to under this provision, then the buyer can seek either to enforce you under its remedies under paragraph 15, or go ahead and extend the closing 15 days. Basically, it says here, and here's how it reads. If seller fails to complete any agreed repairs and treatments prior to the closing date, buyer may exercise remedies under paragraph 15, that's the default remedies, where they can sue for damages, sue for specific performance, or they can extend the closing up to 15 days, allowing the seller to complete the repairs. But this is a buyer's right, not a seller's right. So the seller needs to be aware of that. Okay, other change, and this is a minor change, but for clarification purposes, under paragraph 6D, which is the provision where a buyer can object to items shown in the commitment. Under paragraph 6D, we require the buyer to object to items shown in the commitment on or before a certain period of time from the date they receive that, or closing, whichever is earlier. However, in that paragraph we go on to say, but a buyer really doesn't need to object to Schedule C requirements, because that's something that they don't need to object to. We're going to have to take care of before closing. Well, we just added the words by buyer, where it talks about it's not waived if the buyer doesn't object. Simple addition just for clarification purposes, saying the buyer does not waive Schedule C requirements. Under paragraph 15, which is the default paragraph that we just visited with a minute ago, all we did under paragraph 15 is we deleted a provision that talked about if the seller failed due to factors beyond his control to make repairs and or deliver commitment and survey, what the remedies were. We took that out of the default paragraph because we felt that those issues were already dealt with under other provisions of the contract. For instance, if the seller failed to make repairs, that was covered under paragraph 7F. If the seller failed to have the commitment and the survey delivered, that was covered under paragraph 6B, the change we just talked about, and 6C on the survey, which is already in the contract. All right, another substantive change comes with the Subdivision Information Addendum, including, and it's titled Subdivision Information, including resale certificates for property subject to mandatory membership in a Property Owners Association, Form 37-4. This form also changed as a result of the statutory change, and the required notices or the required information under this form is required as of 1/1/2012. So another form that we encourage you to start using now, because the form that you can use under TREC rules until March is outdated. The new information that is required of the homeowner's information, I think you'll be very pleased with, and it talks about first the resale certificate that the homeowners association has to provide must disclose the purpose of any special assessment, and it must describe all fees associated with the transfer, what the fee is, to whom it is paid, and how much. A lot of people complain that they get hit at closing with fees associated with the transfer that they had no idea were unreasonable, were astronomical, and they didn't have anything that they could do because they get it at closing. So this now is required of the homeowners association to provide on the resale certificate. One of the problems with that, however, is as far as negotiating the addendum that we talked about a moment ago, where we talk about the seller providing a resale certificate to the buyer, and then we talk about fees associated with the transfer, and we negotiate, we say fees associated with the transfer shall be paid by buyer up to, and the seller shall pay the remainder. Generally, you're negotiating that addendum before you have the resale certificate, which actually outlines those fees. So this doesn't help you necessarily on the first negotiation, but at least you will have this information as a go forward. So this information, this form is one that you should be using currently because this information is required as of 1/1/2012. I will submit to you that the Properties Owners Association generally sends their own forms. They don't use the one that we send to them, but and they will include this information because they're required to. But when you request it using this form, you should be using the form that was the date on it is 12/5/11 because this information is required as of January 1. Other changes to TREC forms. We have a change, and these are minor changes, but were as a result of the statutory changes. We have the Seller's Temporary Residential Lease Form 15-5. The term smoke detectors was changed in the statute to smoke alarms. So everywhere you see the word smoke detectors, you're going to see the change from smoke detectors to smoke alarms. Same with the Buyer's Temporary Residential Lease Form, the term smoke detectors changed to smoke alarms. And as a little diversion, note that TAR produces your lease forms that you use. As a result of this statute, TAR also had to change many of their forms. They changed their residential lease form, their residential lease application, lease inventory and condition form, and several others. Be aware of that so you're using the current forms, and TAR has adopted the changes to conform with the statute. All of this effective January 1. Okay, some minor changes that came with regard to the TREC form. The amendment form 39-7. Simply we had changed the title of the third-party financing condition addendum a couple of versions ago to make clear that the third-party financing condition addendum only deals with the buyer's credit approval and not the property approval, meaning the property also had to be approved by the lender for loan approval, as you use the word loan approval. Third-party financing addendum only deals with the buyer's financial wherewithal to be able to afford the loan that they're requesting. So we changed it to call it the third-party financing condition addendum for credit approval. Well, we failed to take that forward to the amendment, and so under paragraph 8, we changed the name of the third-party financing addendum to correct it to its current name. With regard to the another change on the addendum for sale of other property by buyer, form 10-6. This is non-substantive language cleanup in paragraph D. We just deleted some superfluous language, if you will, and that is under paragraph D, where we deleted the word sale of the between buyers and property, because we just said buyer's property, and added the word above for paragraph A. And that was for clarification purposes, but note that one of the confusions on the sale of other property addendum is the contingency. The contingency, and people need to be aware of what the contingency actually is. The contingency is actually buyer's receipt of proceeds from the sale of the property, not just that the property closed. So the receipt of the proceeds is critical there, and that can cause problems because under that addendum it has the words time is of the essence, that if the contingency isn't met, i.e. receipt of proceeds by buyer within the time specified, that the contract terminates. So there's time is of the essence language in there, and the contingency is receipt of proceeds. So we took out some language in here that caused a little bit of confusion. All right. All of the contracts, addendum, and other forms were also updated. One, to reflect the new date of adoption in the top right corner, 12/5/2011, but for, and I've already given you in the outline, the 4 contracts that are now updated to correct the typo. Those will be dated 1/12/2012. The contracts were also updated, as you know, under the sunset provision of TREC and the budgetary constraints that the legislature followed. TREC is having to fund their own operations from your fees versus it coming from the general revenue fund of the state. And TREC, to save some money, has deleted their old 800 number. So that came off. If you'll look at the little box underneath on the last page of your contract, it gives you all sorts of information on how to get a hold of TREC and so forth. So they deleted the old 800 number. And then I don't know if you're aware, but TREC was required to move this summer into state-owned property. So they also moved. So their actual phone number also changed. It's now 512-936-3000. You'll see that in the box. And then they also provided their new website, which is www.trec.texas.gov. And then they changed the form number. And generally the form number just changes at the end. So 20-11 was 20-10. So you know it's the 1 to 4 family by knowing the first number. Other changes yet to come. House Bill 1821 amended the law governing the operation of Property Owners Association. And I know I slip back and forth from the term Property Owners Association to Homeowners Association, but really we try and refer to Property Owners Association when we're talking about the law governing associations that regulate, if you will, single-family detached property. Okay? So note that this House Bill 1821 is a law that governs owners associations on single-family detached. What House Bill 1821 did is they added a provision that now buyers can order the resale certificate. Most of you know that it used to be only the title company, the seller, or the seller's agent could order this from the homeowners association. Now the buyers can order it. Now the property owners associations do have the right to ask for evidence from the buyer that they have some interest in the property. Maybe a copy of the contract, maybe the seller's authorization. I don't know what they'll require, but they don't want just drive-bys and buyers ordering this property information. The statute actually also calls for the buyer to pay for the resale certificate unless the contract calls for it otherwise. Currently, our current addendum that you're using right now says the seller will provide the subdivision information, which includes the resale certificate to the buyer, so it's a seller expense. But the statute actually defaults it to a buyer expense unless the contract calls otherwise. So we may see some changes in the addendum. Also, if a resale certificate was issued within the last 60 days, the Property Owners Association must give a copy to the buyer upon request. This was in an effort, unfortunately, the Property Owners Associations were making lots of money off of these requests from these resale certificates, and they would never allow us to just order a copy. This statute says, hey, wait a minute, Property Owners Associations, you cannot charge if you've already issued one within 60 days. The buyer has the right to that copy without a cost. There's still a provision in there, and HB 1821 didn't change it, that you can order an update for a lesser cost if the resale certificate was issued in the last 6 months. So that's still available, and that's one of the provisions under the addendum that you can get an update. And then finally, what's important, I think, to you all is that the resale certificate must be delivered within 10 business days. What is not known, I don't think, by the public at large is that currently under the law, the Homeowners Association or Property Owners Association has really a total of 17 days to deliver the homeowners information to us. It reads they have 10 days from the first request, written request, and if they don't provide the information, then they have 7 days from the second request before any penalty kicks in. So arguably, the Property Owners Association has 17 days, really 19 days to process it, to get us the information. And unfortunately, when you write in the addendum 10 days for the Property Owners Association to be delivered, the Homeowners Association charges expedited fees to deliver it. And so not only are we paying $250 or $350 to get the resale certificate, aka subdivision information, if we're ordering it faster than the 17 days that they're authorized by law to provide it to you, then they charge us an expedited fee as much as $100. Having said that, this new law said, you have plenty of time to give it within 10 business days. But again, I want you to note this is 10 business days, so it doesn't include weekends. Your contract calls for just calendar days, which include weekends and holidays. This law says 10 business days. If you want to avoid your seller having to pay an expedited fee, you need to think about 10 business days in that provision. But we will see some changes coming down the pike on the addendum, so be looking for that. They did not get that approved yet, and there is a form that was approved for comment by the Commission on 12/5/2011, but I have not seen its posting yet on the TREC website. They post draft forms on the page that says draft forms, allowing you time to give your comment to them. And the next broker lawyer committee is going to be February 9th and 10th. So hopefully they'll get the form posted soon. You can look at it, think about it, and give your comment to broker lawyer committee. Conclusion to my presentation today, and then I will answer your questions, is these contracts have notices in the contract that are required by law as of January 1. They don't affect you unless your property that you are dealing with is covered by a property owners association, and that's a single-family detached home, not a condominium, okay? So just single-family detached home, and or they are subject to a private transfer fee. If your property is subject to either one of those, these notices are required as of January 1. TAR, TREC, and I am trying to encourage you to start using these forms because it doesn't hurt to have the notices in there. So start using these forms now. If you don't give the notice, there is no other form. Neither TAR nor TREC has created any other form to provide the notice any other way. So I encourage you to use the forms. Unfortunately, they're not up on zip forms as of today. According to TAR, it may be towards the end of this month, but they have them up on TextRealtors.com. Another thing that I need to remind you, because I find that agents use templates, you could go ahead and create your template, update your template, and do it now. Many people get in trouble because they forget. They know that they've got new contracts, but they fail to update their templates. Go ahead and update your template now. And then finally, I did provide an appendix to this outline that was emailed to you that will give you a list of all the new form contracts with their numbers so that you know what you're going to be looking for. And again, unfortunately, I would tell you they're all dated 12/5/2011, so you know you have the new form. But know that the 1 to 4 family residential contract, the new home contract, both completed and incomplete construction, and the unimproved contract, the newest form will be dated 1/12/2012. And unfortunately, those are not posted yet. So I hope that was of value. I will turn to the questions now, and since I'm the only one that sees these questions, I will read them to you and then try and address them as time will have it.
If you have additional questions, please be sure to put them in the questions pane now, and we'll see those, and Dawn will go through and answer each of them individually.
All right, the first question came, is there a time limit on the buyer's right to terminate for failure to give notice? On the Property Owners Association notice. There is no time limit. Basically, you fail to give notice on or before execution of the contract, your contract's defective. And so there is no notice under the statute that I'm aware of, and I reread House Bill 1821 last night and saw no time frame on that. With regard to the private transfer fee, there's actually a penalty in the statute that talks about injunctive relief for failure to have it in the contract when it's executed. Since those have not been tried and true, I don't know what the injunctive relief would be, but basically you can terminate the contract again anytime. The next question is the private transfer fee the same as the transfer fee to the HOA? Unfortunately, the statute says if the property is subject to a private transfer fee, you have to give notice. So I would argue an HOA, a private transfer fee to an HOA, is the private transfer fee that they talk about the statute. But the statute actually exempts from these restrictions. Basically, the statute is getting rid of private transfer fees, but for private transfer fees to the HOAs, and there are some other exemptions. One, your commission is exempt as a private transfer fee, but there are some other exemptions. For instance, if a private transfer fee is paid to a charity, that the proceeds are used directly to benefit the property. So those are exempt. The way the statute reads is, again, and if you look at the notice, it just says if your property is subject to a private transfer fee, it's subject to the chapter 5 of the Texas Property Code, which exempts those. Again, on the safe side, you need that private transfer fee in your contract. You won't even know you've got it involved unless you have your title commitment. Okay, someone asked this question saying, so this means we will need to have the HOA papers when we list the property instead of getting them from the title company after we get an executed contract. Of course, to be able to negotiate who should pay for what fees associated with the transfer, it would be nice to have the resale certificate ahead of time. But I would argue that it's nice to have the resale certificate ahead of time because if you look at your addendum you're using now, right now the way most of you write that, because you ask the title company to order the resale certificate, you give your buyer a second option. Under that provision, if you don't have the resale certificate before you execute the contract, it says the buyer has the right to terminate the contract within 7 days of receipt of the resale certificate for any reason. So under that addendum, if you don't want to give your buyer a option, a longer option than what you provided in paragraph 23, or, excuse my blasphemy, a free option, you don't want to use that first choice and you get the resale certificate ahead of time. I think your question was, since you don't have all the information ahead of time, should you try and get the resale certificate so you could negotiate the fees associated with the transfer better on the contract? And yes, I would say as well, that would be a good reason to have the resale certificate. All right. Okay. So as usual, this is the next question. So as usual, if we are using TREC forms, we are covered because they are already in the contract. Yes, that's what Broker Lawyer Committee tries to do for you. When a new notice comes into being, if we can get it in the contract without making the contract too long, because we also balance that need to keep the contract a reasonable length, then we will insert the notices in the contract so you don't have to provide a separate written notice. So yes, if you use the new contract, the ones that are not mandatory until March 1 and unfortunately aren't on zip forms, and unfortunately the 2012 form isn't even up on TREC yet, but if you use that form, you will have covered your notices. Do the contracts, here's the next one, do the contracts have the bold and underlined sections Dawn just spoke about corrected? No, not yet. any day now. I've been checking TREC website any day. The bolded underlined provision are the 3 sentences above what is currently bolded and underlined. And the bolded and underlined provision that you have now won't be bolded and underlined. It'll still be in the contract, but it won't be bolded and underlined. Is there any change on HOA being of record or easier to locate, as well as water co-ops for the property? On HOA, under the statute, it does also make clear that the Property Owners Association, again, I'm talking about single-family detached, must post on their website, if they have a website, all their dedicatory instruments. So hopefully they'll post all those on the website. Many owners associations don't have websites, but really what's happened is once this law came into place, there's a lot of management companies governing these properties owners associations, and they also have to post them. So hopefully you will see them on their websites. They'll be easier to find. Water co-ops, I don't have an answer for that, and I'm sorry. So I don't know if the water co-ops will be easier to find. Again, it's a title search, and it's when the title companies pick it up. Okay. This is a question about turning on the utilities by the seller, but it doesn't say that the buyer can terminate. So what is the consequence if a seller fails to turn on utilities? The buyer does have the right to terminate under paragraph 15 of the contract, which is a default remedy. Arguably, if the sellers fail to turn on utilities immediately and cause the utilities to remain on, they're in default of the contract, and the buyer can pursue their remedies under paragraph 15. House Bill 1821, does this refer to any buyer that requests it within 60 days, or is this just the same buyer? Oh, this question was if a resale certificate has been issued within the 60 days, who can request a copy of it? Does it have to be the same buyer? No, this was intended to be if there came a second buyer. So if a resale certificate was issued within the last 60 days, and let's assume they ordered it, the contract fell through, another buyer comes in within 60 days, this buyer can get a copy of one that was already issued to a previous buyer. Again, keeping the homeowners association from requiring us to get multiple copies and paying for them. This question, what is the maximum late charge an HOA is allowed to charge? An HOA is charging a $50 late charge on a $45 a month assessment if not paid by the 10th of the month. Interestingly, I can't tell you that. There's no statute that I'm aware of that governs that, and it's the homeowners who own the property that can vote that in, but unfortunately they're relying on their management companies. When will ZIP forms be updated with the new forms? I'm sorry, I don't know, but keep in contact. I'm sure Annette here at the education, your department at MetroTex is a wealth of information and very helpful. Stay in tune with them and they'll help you. Can POAs still require the fees be paid before providing the resale certificate? The question really is that here's what's happening. The POAs are charging for, are requiring us to pay upfront for the resale certificate. The new statute did say that the Property Owners Association can require the fee paid upfront, but they can't process the fee until they're ready to deliver the certificate within the time required. If they can't deliver the certificate within the time required, they can't charge the fee. So this may help us if we order one and then we cancel a transaction before they issue the certificate. Perhaps we can save a few fees that way. Okay, in paragraph 7, is there a blank where we can put a number of days that it needs to happen? I'm not sure if that question is under paragraph 7A, it's the immediately. If that has to do with seller, the definition of immediately for a seller, there is no blank to put a certain number of days in there. If you're wanting to put in a date by which the buyer makes an inspection, remember 7A allows the buyer to make inspections at reasonable times, and that includes a walkthrough even before closing. Okay. I noticed my agent colleague is representing a client who's buying REO property. The seller is an outfit from California, which is using outdated promulgated contract forms. What do you do about this? You have to understand that a principal can use any contract they want, but you can't then fill in that contract for them. If you're representing and you're writing, you as a licensee are writing the contract for your principal, you must use promulgated forms or you are practicing law without a license. If the principal is writing that contract, they can use any form they want. Okay. Sorry, I guess I skipped one. What recourse does the buyer have if the seller will not turn on utilities? Again, it is the default remedies under paragraph 15. The buyer has the right to terminate the contract, sue for damages, so forth and so forth. So again, the seller is in default if they fail to turn on the utilities as required by the contract. Remember, your REO clients may have an addendum, and it may be covered in the addendum that they don't turn on utilities. The next one is, please clarify if there is no charge to the buyer for a resale certificate if it is completed within the 60 days. Yes, the statute does not allow a fee. If a new buyer comes along and a resale certificate was issued within the last 60 days, the homeowners association must provide a copy of that. There is no fee for providing that information. Sellers may not want to order resale certificates since they are only good for a minimal amount of time, which would make it tricky. Resale certificates will have to be updated for a cost, correct? That is one of the biggest problems that we've argued with the property owners associations. There is no requirement as to how soon that resale certificate has to be. And in fact, unfortunately, some of the management companies say this resale certificate is only good for 30 days. That is not correct. What they're just trying, that resale certificate is good forever. It's basically a statement of condition of the homeowners association as of that date. So that resale certificate is good forever. The difference is if you've got a monthly homeowners fees, they're not saying whether that next month has been paid. That's the only difference. And if you can get an updated statement that they've paid the next month's fees, then you're probably okay. The other thing is sometimes you have homeowner associations that are annual payments, and so when it says it's outdated within 30 days, unless they amend or whatever, that resale certificate is still good. That is what is causing us some problems with the Property Owners Association. That's the seminar in itself. We've been working on that quite a bit. How are the POAs being educated as their timeline? Another webinar, because we have been working on it hard, fast, and furious. And for those of you who've heard me publicly speak, I go off on a soapbox on POAs, and I'm sorry I can't talk at length on that quickly. Okay, could you put in special provisions that the clock starts ticking on the option period from the date utilities are turned on? I prefer you not, and let me tell you again why. Is because you're thinking of the option period in a very limited fashion. You're thinking option period only in terms of inspection. And I preach, preach, preach that you need to think of your option period as a feasibility study. It's an option throughout the contract. So it's not just inspections. I prefer you not do that. Just give yourself enough time and know that immediately means seller needs to get them on immediately. And if he doesn't, he's in default. I have sellers who cannot afford to turn the utilities on. So the seller cannot refuse even with a buyer agreeing. How would I protect the seller and the contract? Write it in paragraph 11. Yes, if you have a seller who will not turn on the utilities immediately, you better write it in special provisions. And basically you can say, notwithstanding what's covered in paragraph 7A, seller will not turn on the utilities. Now, your seller needs to direct you to add that special provision. Okay, several are repeat questions, so I'll address it again. How is immediately defined for turning on utilities? I would argue it's within a reasonable time. I think the seller needs to, the minute he gets the contract executed, call the utility companies. And if the utility companies say they can't do it for 5 days, the seller has still met his requirements. He's ordered it to be turned on. But immediately is going to be defined by the reasonableness of the circumstances. So I'm sorry, I can't help you with that. That's what a 12-man jury decides, what's the reasonableness of the turning on utilities. Bottom line is it no longer just says they'll turn on utilities for inspections, but rather they immediately turn on. So in my opinion, you need to encourage your sellers to call immediately they get an executed contract. And there's no excuse not to, because oftentimes they're negotiating the contract for several days. They can be prepared to turn on utilities. How would a buyer know if there has been a fee paid to the POA within 60 days? I don't know that a buyer would know that, but a seller probably would. So we would need to ask the seller if they have already ordered the resale certificate within the last 60 days. Have I answered? I think so. Okay. This last one, and I think I'm running out of time. Please restate what was just said about the option not being limited, being for the entire contract. Your option provision covers every provision of the contract. It basically says that the buyer has the right to walk away from this contract for any reason. So if a buyer thinks they have overpaid for the house, I don't care the condition, I don't care anything, they can walk away for the contract. If they get cold feet, if the stock market goes down, they can walk away from the contract. The problem is too many people tie the option just to inspections, and they get themselves in trouble because even if the property is pristine, the buyer still has the right to walk away if they walk away within the time frame. I think you need to use the option period more comprehensively. Check your deed restrictions, check your title commitment, check your appraisal, check your survey, all during the option period, so the buyer feels very comfortable with it before the option period expires. That's a seminar in and of itself. We may do that another day. I thank you for the time. Annette is giving me the hook. I'll let her close, but thank you, and I hope you got some value out of this webinar today.